Thank you for visiting the Waterkotte website and our Rape and Sexual Assault Defense Lawyer in Missouri website page. Regardless of the crime, we believe everyone is entitled to the best possible legal defense in the state of Missouri. We have created this audio version of our website page to help you better understand our services and protect your future, freedom, and reputation. If you have been charged with rape and sexual assault in the state of Missouri, we can help. Don't face the state and court system alone during your rape and sexual assault charge. Contact one of our Missouri Rape and Sexual Assault Defense Lawyers today at 314-900. Help to protect your rights and future. Waterkotte is committed to handling all rape and sexual assault defense cases with confidential care and understanding. We are not here to judge you. We believe that everyone in Missouri, regardless of the crime they have been charged with, deserves an aggressive legal defense and to have their legal rights protected. With that being said, let's discuss hiring our rape and sexual assault lawyers in Missouri and setting up a free consultation with our attorneys. Sexual Abuse Lawyer in Missouri. Protecting your future. Your reputation, freedom, and future are on the line. While the public and acquaintances may rush to judgment when someone's charged with a sex crime, Waterkotte is non-judgmental and will listen to what you have to say. We know there is more than one side to every story. Rape laws in St. Louis and Missouri. There are 4 types of rape under Missouri law. Don't face these accusations alone. Contact one of our lawyers today at 314-900. Help to protect your rights and future. Rape in the first degree. Under Missouri Revised Statute, Section 566.030, a person can be charged with first-degree rape if they have sexual intercourse, defined in Missouri Revised Statute, Section 567.010, as any penetration, however slight, of the female genitalia by the penis with someone who is incapacitated, is incapable of consent, lacks the capacity to consent, was forcibly compulsed through violence or threats, was drugged without their knowledge or consent. The punishment for first-degree rape is 5 years to life imprisonment. However, if the offense is an aggravated sexual offense, meaning the alleged victim was seriously harmed, a dangerous weapon or object was used to threaten them, there is more than one alleged offender, or the alleged offender was a family member, the sentence is 15 years to life. If the alleged offender is a persistent or predatory sexual offender, the sentence is life in prison without parole. If the alleged victim was less than 12 years old, the sentence is life in prison, with the possibility of parole after 30 years, or the possibility of parole after 15 years if the alleged offender is at least 75 years old. If the alleged victim was less than 12 years old and the crime was outrageously or wantonly vile, horrible, or inhumane, and involved torture or other aggravating factors, the sentence is life in prison without the possibility of parole. People convicted of committing or attempting first-degree rape are eligible for a suspended sentence. Rape in the second degree. Under Missouri Revised Statute, Section 566.031, a person commits second-degree rape when they have sexual intercourse with someone knowing that they do not have that person's consent. It is a Class D felony, which carries with it up to 7 years in prison and/or a fine of up to $10,000. Rape in the second degree can be complicated because the law itself is vague. While it does not require forcible compulsion or an alleged victim being unable to consent, the alleged victim's silence can be seen as either consent or not consent, depending on the judge, jury, and how your defense lawyer argues in court. Sodomy laws in Missouri. Missouri also has laws against sodomy in the first degree and sodomy in the second degree, the definitions of which and sentencing for are largely similar. Sodomy is defined as deviant sexual intercourse, or any act involving the genitals and a hand, finger, mouth, tongue, or anus of another person or an object. Apart from the definition of the act, the only difference between Missouri rape laws and sodomy laws is that if someone is convicted of an aggravated sexual offense while committing sodomy, the minimum sentence is 10 years and not 15. How Combs Waterkotte can defend you against rape charges in St. Louis, Missouri. No matter the nature of the charges brought against you, you deserve to have a top-level defense team and to have your day in court. While the opinions of the public, your co-workers, or even family and friends can change because of an allegation, in a court of law, you still have the presumption of innocence. In order to clear your name or get the best possible results in your case, our St. Louis, Missouri rape defense lawyers will investigate whether any evidence against you was legally obtained, evaluate the reliability of eyewitnesses, look for inconsistencies in the accuser's story, and examine their motivations. Work with prosecutors and/or the judge to have your charges dismissed or reduced. Persuade a jury that the state did not prove the charges beyond a reasonable doubt. Examine forensic evidence for accuracy and relevance. Challenge the admissibility of certain evidence. Assess the credibility of expert witnesses. Consent laws in Missouri. Rape and sexual assault charges center around the idea of consent, whether it was given and whether the alleged victim was capable of giving it at the time of the alleged offense. Unfortunately, the state of Missouri does not have its own legal definition of consent, which can cause uncertainty in the courtroom. One legal definition of consent is when a person voluntarily and willfully agrees to undertake an action that another person suggests. The consenting person must possess sufficient mental capacity. When someone is not able to consent. In rape and sexual assault cases, the action agreed to is a sexual act. Missouri House Bill 215, signed into law in 2013, offers clarification on when someone is not able to consent. When they are too young, the Missouri age of consent is 17. They have a mental disease or defect which doesn't allow them to understand the acts. They are intoxicated by drugs or alcohol in such a state that they cannot make reasonable judgments. If they are passed out from drinking, being drugged, or are otherwise unconscious. As lack of consent is central to a rape conviction, our St. Louis rape defense lawyers will make a full investigation into the charges and see if we can use the presence of consent as an affirmative defense. Call Combs Waterkotte's Street. Louis, Missouri Rape Defense, lawyers for dedicated representation. If you're facing rape or sexual assault charges in Missouri, you need an experienced, knowledgeable, and non-judgmental sex crimes lawyer in St. Louis to defend your rights in court. Combs Waterkotte helps people in bad situations, no matter how they got there. Call us today at 314-900, help to speak with an attorney, or contact us online and schedule a free, confidential, no-obligation case review.